This is the last civil litigation presentation. Following this presentation, I'm going to provide a final review for civil litigation. Now, of course, civil litigation, we're talking about litigation, so I would be remiss not to go over the trial. You might wonder why the trial was last on the list. Out of the whole litigation process, particularly for the paralegal, the litigation, the actual trial part of it, is one of the smallest parts of what you have to deal with. The preparation is more important for the paralegal. And even for the attorney. In most cases, lawsuits are settled before trial. No one wants to leave a group of jury members to decide their case. It's like throwing up a coin in the air and hoping it lands on heads if you called heads. There's no telling what kind of jury you're going to get. There's no telling how the evidence is going to end up being presented in court. There's a lot of variables that go into trial that can be put aside if there's settlement ahead of time. So a lot of times you're going to see the parties come together even moments before trial to settle the matter and postpone or get rid of the fact of even having to have a trial. Because of the lack of importance that litigation, the actual trial process has for a paralegal, we won't spend much time on it. But you need to know what the process is as a paralegal, just to have an idea. And in reality, the civil litigation process, the courtroom process, is very similar to the criminal litigation process, or the criminal trial process. So some of these same things will apply. What I'm going to go over first is just the broad stroke, the concepts that we're going to be going over, so you can see the progression of trial. Now, we've already done discovery. You've worked with the attorney to pretty much know what's going to be said. There aren't going to be any surprises. Once trial starts, for the most part, the attorney has prepared what the jury is going to see, has anticipated what the opposing side is going to bring up, and how that's going to be overcome. So the trial is almost just a performance to repeat the preparation that's been done. Of course, there's always variables that could come up, but in general, the questions that are going to be asked are already prepared. There may be some tweaks during the trial, but for the most part, everything's going to be prepared ahead of time. So, what's the first part of the trial? Jury selection, also known as voir dire. Jury selection is the point in time that the jury is impaneled. It basically is you don't just get the random jury that's picked for you. The attorneys have opportunities to change what kind of jury they're going to get, and we'll go into that in a little bit more detail in a moment. After that, you're going to have opening statements, Notice I used the word statements. It's not opening arguments, it's opening statements. And we'll go over that, why that's important. Then there's the plaintiff's case, the case in chief. Then the plaintiff will rest. There's the defendant's case. Then finally, you're going to have closing arguments. Now here's where we're using the word argument. We're going to have closing arguments, and then we're going to have a jury verdict. Now I'm going to present this under the assumption that the right to a jury hasn't been waived. So we're going to assume that the fact finder is the jury. So let's start with jury selection, voir dire. Voir dire is used two ways in a trial. The first way is in jury selection. The second way is when an expert needs to be qualified or evidence needs to be analyzed before it's permitted into court. Basically, the idea of voir dire is sort of vetting. It's the ability to ask questions and come up with a conclusion, some decision. In the sense of the jury selection, voir dire is asking the jurors questions, the attorney asking the jurors questions, and then the attorney deciding whether or not that juror is biased or otherwise bad for the client's side. Voir dire can be done in several ways, and ultimately the purpose of voir dire is to get a fair jury. While randomizing a jury could lend to fairness, the voir dire, the jury selection procedure, helps ensure that both sides get to pick and choose a bit of what kind of jury they're going to have. Imagine a case where there's a defamation trial. It's an issue of defamation. It just so happens that the random jury selected for this case, every single one of them was a defendant in a defamation action. Probably very unlikely, but assume that does happen. That would be pretty bad for the plaintiff in the case. The case would pretty much be decided ahead of time. I mean, after all, one would easily expect that a jury full of people who were sued for defamation aren't going to be too kind to the person doing the suing. So there are two types of challenges that attorneys can use to kick jurors off or potential jurors off who have a bias or some sort of issue that would prevent the juror from rendering a just verdict.